Welcome to A Lawyer's Guide to the Galaxy, a podcast about geek culture by lawyers, with your hosts, Ben Siders and Kirk Damman.
Today's episode is controlled by the War Operation Plan Response Supercomputer, because you don't actually control anything.
Welcome back to The Lawyer's Guide to the Galaxy, the podcast that asks interesting questions and speculates about the answers without ever coming to any real conclusions. With your host, Ben Siders, that's me, and the other guy is Kirk Damman.
That's Kirk, as in the captain of the Enterprise.
We are intellectual property lawyers and certified geeks practicing law in St. Louis, Missouri. You can find me, Ben, on Twitter at Benjamin Siders, and you can find Kirk at KirkDMN. You can follow this podcast on Twitter at LGGPod. Today is part 3 of our discussion of video games. We're going to do yet another update on the Fortnite Dance case, which keeps changing from underneath our feet.
Are people not tired of video games yet? Oh yeah, this is a podcast for geeks. Of course we're not tired of video games yet.
And we're going to talk about the original NES control pad patent and some other interesting things. So welcome back. This is, like we said, part 3. We had originally not intended to do even a part 2 on video games, but there was just so much to cover here.
Yeah, there ended up being a lot of things. Now we also deviated a few places and wandered around, but
yeah, well, that's as per the norm. A couple interesting things that happened before we get into the the substance of this. One is Kirk, the Oscars.
Yep, the Oscars happened.
They happened, and
without a host.
Black Panther won a bunch of stuff.
Which is really kind of surprising, although I have to admit that it, quite frankly, deserved it.
Yeah, I mean, it's only surprising because comic book movies don't traditionally play that well with the Oscars. It's not seen as being serious enough.
Well, I think as we've encountered, from other podcasts we listen to, there's a lot of discussion of if you want to win an Oscar, you make a docudrama.
Yeah.
Or something similar in conjunction with it. And I think there is a lot of, formulaic Oscar-type movies.
Well, you got to make something that the Academy's not going to feel self-conscious voting for. Have people say, wait, are you into movies or are you not?
Although one could say, were they self-conscious voting for Green Book? But
a whole other question. But, Black Panther's interesting because I think the political and social context of the film, combined with it just being a really good movie.
Yeah, it was an extremely good movie.
Gave the Academy a little more cover to be, to kind of go outside of the usual box of what they vote for.
Yeah, I mean, it's not like this is unprecedented. I mean, we saw it with Lord of the Rings, Return of the King, obviously,
But I think it won in categories we don't normally see, right? We were talking before the mics went live that movies like this typically win, costume or something like that.
Yep.
But we thought, I think it won costume this year.
Yeah, and I think it did win costume. At least I hope it won costume, and I think it well-deserved costume, even if it didn't win.
Because usually the costume Oscar goes to, like a historical, or a biopic or something like that.
Yeah,
something
docudrama,
something historical and weighty and serious about somebody that we've probably never heard of, or maybe we have heard of, but it's an excuse for people to get expensive fabric and dress up in, 17th century clothing. Yeah. But we were just talking, like, Black Panther is actually harder to do in a lot of ways because there's no model for it. There's no text to go consult and say, how did people dress? We're taking traditional African clothing and then projecting it forward into this super advanced society. What does it look like? How does it change?
Yeah. And it still needs to be recognizable, but it can't be traditional. It needs to look modernized. Yeah. It needs to be particularly functional. I mean, we're talking about like battle dress, stuff like that, where this isn't just ceremonial. This is something that needs to be very functional, have it make logical sense. And that's, I don't know if I've mentioned it on the show before, but I used to do theater tech. And I joke about it, sort of repeat, I did a lot of light design, a lot of sound design, some set design. I never really did costumes, and the reason I never really did costumes is because I was terrible at it.
Yep, same here.
Because trying to come up with costumes can be extraordinarily difficult. I worked with some incredibly talented people that are good at coming up with costumes and just thinking about how to do costumes. But I really think that it's oftentimes these technical awards really get glossed over by the Oscars, and we forget how important they are. You were talking about, again, before the mics went live, how bad lighting design can really screw up a movie.
Yeah.
You have something where it's like, oh, this is inside. There's the running joke of how a single lighter can light an entire room because it has to, so you can see what the actors are doing. But making that look right still requires you to do it correctly.
Yeah, for sure.
And there's a lot of weird places where, you can get into, hey, depending on where you're filming, if you're on a soundstage, if you're outdoors, sort of stuff like that, making sure you get these things right can be a big deal. And it's not so much that getting it right right makes the movie better. It's getting it wrong makes the movie far worse.
It ruins your suspension of disbelief. And the example I gave, so Empire Strikes Back, the Dagobah scenes, I think all take place on a soundstage somewhere. Yeah. But, although I know that in the back of my head, and there's a couple spots where you can kind of tell, for the most part, I don't really notice. Like, the narrative moves along quickly enough, the story's interesting enough, and the set design and the lighting are done well enough that I can convince myself that he's on a swamp planet. Yep. Compare that to the opening sequence in, what was episode 7 called? I just blanked on it. Shoot. Not The Last Jedi.
Force Awakens.
Yeah, The Force Awakens. When they're on Jakku and the stormtroopers arrive, that just feels like a soundstage to me. They're in a studio with a black backdrop because there's no stars. It doesn't feel open. Like the echoing is weird. The sound design is weird. That whole sequence just falls down for me because of that.
And it's one of those things where, again, I think that, there was a lot of comments this year about like dropping tops from the Oscars and primarily technical Oscars and things like that. A lot of these things make and break movies, and they really do. Editing can completely make and break a movie.
Well, you know why? Because these are the things that, if they're done successfully, you don't notice them. Yeah. It's not like acting, where when someone's doing a great job, you're just like, wow, what a performance. But the makeup, you only notice if they suck at it.
Yeah, though you do notice sometimes if it's very good, depending on what it is. But that's where I think like costuming is a great example, because I think a lot of times the reason the historical cases win, and like I've talked with a friend of mine who does makeup, who did fairly professional theater makeup and did costuming. And she always used to comment about the makeup, and she said, it's hard to do makeup to make somebody look like a normal person. It's very easy to make them look like an alien. Yeah. Even though the makeup requirements of looking like an alien are dramatically more increased, it's a relatively easy thing to do because there's so little reference material. Yep. And I think that's why you get so much of the docudramas, the historical costumes winning, is look how accurate this is. Look how well it's portrayed as to that this is really what the things should look like, and they're really well done, versus the idea of somebody looking at it and saying, look how creative this is. If I need to film a World War II movie, I can go down to a museum and look at the actual uniform.
Yeah, you know what it's supposed to look like.
Yeah, you know exactly what it's supposed to look like. I can probably even get accurate cloths. I can get components that can be made and cast and directly done from it.
It's not going to look like it's made out of modern synthetics and stuff like that. You can do that.
Whereas when I need to, make, Black Panther's costume, what does Black Panther look like? I need something that's functional. He's got to be able to move and look like a cat in some respects.
Well, this is the Star Trek problem too, right? Like when they the Next Generation was famous for having ludicrously impractical costumes, and for some reason all the sheets were made of Mylar. I never understood that. The Next Generation, and they wear weird clothes, and it was just making it look futuristic for the sake of it. Never mind that other than breathability and stuff like that, the technology of textiles is ancient. We don't need to. How much are they going to improve on it in the next 300 years to where everything's going to look like Mylar?
The best one of those, I still think, you want to talk about bad costume design, trying to make it look futuristic. Go no further than Moonraker. let's just leave it there. Of the idea of how badly you can screw up costumes of just trying to make them look futuristic. And I think there is something relevant to that, and the idea of saying, we have this thing in movies at times where we just make things modern to make it clear that it's a science fiction movie. Yeah. Which is kind of weird in many respects. The Starship Enterprise is a perfect example. There's no square corners. Everything's round.
Why not? That's so expensive and impractical.
Yeah. No, admittedly, there's things to be said for certain rounds for cleanliness and things like that. But there's a lot of things that just make no sense in conjunction with it. But then you also get the fun ones where they combine almost the modern with the anachronistic. I'm thinking the most recent Battlestar Galactica, which still had phone handsets.
Yeah, it didn't have wireless phones.
Yeah, they don't have wireless phones. At the same time, it works in there because it's kind of this idea that it's this kind of slightly dystopian future.
Yeah, and it's submarines, basically.
Yeah, it's a submarine, that kind of thing. So I think, again, there's so much to be said for technical stuff, making and breaking a movie, making and breaking a TV show.
Well, it's how subtly you can work these elements in to where the audience doesn't really notice. Like Battlestar Galactica, when I first saw that, this is the new version we're talking about.
Yeah, the newest version.
It's all just done like sort of conventional naval warships that happen to be spaceships.
Yeah.
And other than the jumping technology and whatnot, the people who are on the show just kind of treat the ships like any other kind of ship. And so when the phone rings and someone picks it up and says Galactica Actual, it's all done seriously. It's all played straight. The actors don't show any awareness of how silly it looks. Yeah. And if you can do that convincingly, and this is part of a combination of technical aspects, directing and acting, then you make the audience suspend their disbelief and they just accept this as the reality of how this universe works, even though it makes no sense.
Yeah. Well, particularly I think when you get into slightly dystopian universes, which obviously Battlestar Galactica is, it's not the everything's perfect universe. But, if we really want to get into sort of, like set design and the concept of how a universe looks, I mean, let's talk Blade Runner.
Yeah.
Blade Runner has many things about it which, today's day and age, there's no way that's the future.
Yeah, it's a very environmental film.
Yeah, but it's also because of the environment when it was made, Pan Am was a big airline. Yeah. So that's why Pan Am is dominant in the movie, which obviously if we look at it and say we're projecting that forward to that day today is totally meaningless.
Did you see the new one, by the way, with Ryan Gosling?
I have not seen the new one, and I really want to see it.
They preserved the Pan Am thing. Like the new one still it takes place like even further into the future.
Yeah.
And they still have these Pan Am advertisements, which is kind of brilliant in a way because you can't say Pan Am doesn't come back. Become a thing again.
Well, but it's also, I think the other thing with it is it lends itself again to that dystopian feel of Pan Am's a big, the best example, the one that I can use is sort of a truly, I think, very quick presentation for a dystopian universe is the beginning of Watchmen.
Yeah.
Which really does a great job of saying, no, wait, this is not the real universe we're in very quickly right up front.
Done subtly, too. Like Nixon wins a third term. Yeah. So first of all, Nixon did not get reaconed, and certainly there's no such thing as a third term at that point. Yeah. So it's not correct.
Yeah, and I think that, and that's, 5 seconds, in conjunction with it, and immediately it sets up, no, we're in a dystopian universe, and we're in a dystopian universe that's got some ethics issues.
Yeah.
That's, I think the reason they chose Nixon is the way it was. Now, obviously that's, somewhat from the original comic book and everything else, but it's kind of great to see these kind of technical aspects of movies like this where they do really work. And like we mentioned, talking about previously about Annihilation, and the sets in Annihilation are just brilliant.
That film is everything in there is very well done. The sound design is well done. The sound design
is also extremely well done. Yes,
to the point where I'm going to have nightmares. That's a great point. Let's talk about the other interesting thing that you sent to me the other day. Yes. The Star Wars Always trailer.
So this was sent to me. I actually encountered it in some of the other media that I encountered. If you have not seen it, get on YouTube and search Star Wars Always.
We should say up front, this is not new Star Wars content.
Not at all.
And it's not official Disney/Lucasfilm Star Wars content. This is a fan project, basically.
Yeah, it's a fan project, but it's by a guy who's known for doing editing.
Yeah. Topher Grace, formerly of that 70s show, and I think he was in Ocean's 11. I think he had like a bit part at the beginning of that when George Clooney is trying to teach him how to play poker.
But I think the key with it is he does editing. He supposedly does editing just for fun. Like, it's kind of the things. This is clearly unofficial, but he is very good at it. And what he does is he edits all of the Star Wars movies. So, whatever you want to look at as 11, I guess is the correct total as to what we consider movies.
Three original, 3 new.
3 prequels.
That's right. 3 original, 3 prequels, 2 news. What are we up to there? 8?
So 8 plus Solo plus Rogue One.
Rogue One, that's 10. What am I missing?
So I guess it is 11.
Yeah, I guess that's it.
Yeah. Is that right? No. Yeah, that's right.
Close enough.
Whichever way it is, it's 10 or 11. But
it's a lot. It's a lot to mix together.
He uses scenes from all the movies. He presents it as a movie trailer. It's a 5-minute long movie trailer, so it's obviously
he also uses
long movie trailer.
Unused scenes. There's a bunch of scenes from Star Wars involving Luke and Biggs on Tatooine, where Luke's looking up and watching the battle in the sky. They're mostly finished scenes, but you can tell they're rough cuts.
Yep. What I also think is interesting is he uses quite a bit of the special editions.
He does, yeah.
Which I thought was an intriguing thing. But the comment with it is that he presents it as sort of the Star Wars being an entirely one saga.
Yeah, as an entity.
And it's so well done, and he does some just fantastic cuts of the way things work together. The one I shot you in particular, which is you watch it, it's the Yoda voiceover with, no, there is another.
Yep.
To Ben Kenobi. In conjunction with it, you hear that voiceover, and the immediate jump cut is to Rey. Mm-hmm. And it's like...
It's really well done.
That's so well done. It's like, it's just a brilliant presentation of this way of sort of making this.
There's one spot in there where he intermixes Obi-Wan Kenobi's lines from the original movie with somebody else's lines, and I forget who. But they're 2 scenes that have nothing to do with each other. And
Kylo Ren's, actually?
I think they were Kylo Ren's.
Yeah.
And they're made and filmed filmed like decades apart, but they blend together seamlessly. It's really well done and worth your time to check out.
Yeah, I would definitely check it out and see what it is. And again, I think it's fun. We're just talking about sort of the less appreciated things of editing. This is all editing. It's all basically footage. Now, yes, some of it's special edition footage. There's some of it which is probably secondary DVD footage. I think the Biggs is on some of the special edition.
Yeah. Speaking of which, this just occurred to me. We ought to be getting a teaser trailer for 9 pretty soon, right? That comes out in December, I think.
Presumably,
doesn't it?
yes.
I'm pretty sure that one's December. And I think the teaser trailer for Last Jedi. I seem to recall I was at an event in April when that teaser trailer first came out. Maybe that was for Rogue One, but sometime in the next few months we ought to be getting something because I know primary filming has ended.
Yep.
Because John Boyega on his Twitter feed, I follow him and other people who are in Star Wars.
Involved in Star Wars.
Shocking. He had tweeted a picture of him and Disney, Daisy Ridley and Oscar Isaacs on set on the last day of filming, which looks like it takes place on Jakku. So I guess they go back there or some other, maybe it's Tatooine.
Well, you've got to have something on Jakku, I think.
Something has to be on a sand planet because Star Wars. So.
Star Wars.
So I know primary filming has ended and they're in post now. So we should be getting something in the next few months as far as a teaser trailer goes. So be looking for that.
Yeah, but I think it's definitely worth your time to look for it. I mean, I like fan projects. A lot of times it can be kind of fun. This is one that I think it really shows sort of, I think, great trailer design and also just generally as to what it is. I like trailers. Yeah. I always commented about it that, I mean, the first episode 1 teaser trailer is a brilliant piece of film editing.
I got so excited, and I was so disappointed.
I know, and I think that's what everybody's saying. Like, watching that teaser trailer, like, chills go up your back. You're like, oh my goodness, this is going to be such a great movie, and then it's not.
Yeah.
And you really see stuff like that. I mean, the first time I remember seeing the Independence Day, Super Bowl ad, everybody's like, oh my goodness, what is this going to be about? And that's a movie that I think Independence Day is good. It's far from a great movie.
It's silly. It's silly. It's the sci-fi equivalent of a comedy. It's an action comedy, sci-fi, weird movie.
Yeah, it's pulpy entertainment. It has plot holes up the,
Have you seen the new one yet? The Independence Day?
No.
I forget what it was called.
What was
the new one? Yeah, I didn't either. I've heard it's typical modern stuff. It has to be dark and gritty and realistic. No, it's Independence Day. Don't pivot that way. It doesn't make any sense. Well, so one more thing before we get to the Carlton Dance case update. I was Googling around to see if there was anything new on the Disney Characters for Hire case, and I got a bunch of hits back for other companies offering similar types of services, and one of them was live fairy tale characters. And I thought, well, that's a clever way to avoid Disney's trademarks and copyrights. We'll just call them fairy tale characters. But then I clicked the website, and my first impression was, these are not fairy tale characters. These are just ripoffs of all of Disney's stuff. How is this company still in business? So I printed a couple off and showed them to Kirk on the way over. And the more we looked at them, the more we found that there were differences.
Yeah, there's clear
subtle
differences.
To where they give you the overall impression of the original characters, but the names are different, comically different. We'll talk about some of those. And the costumes themselves are just different enough that maybe they get around it. So the first one they had was a guy in a very dark costume that gave the impression of a ninja cat of some kind. And I showed it to Kirk and I said, what is that? And he goes, it kind of looks like Black Panther.
My immediate take is it looks like Black Panther, but he seemed to be missing his armor.
Missing pieces, yeah. Yeah, so that's not Black Panther, that's Panther Hero.
Yeah.
And then we had a blonde woman in a blue and red costume with a cape and a big S on the chest. That is not Supergirl, that is Woman of Steel. We had the green muscular guy with the curly hair, that is the Incredible Giant. And then we had some more interesting ones. There was Prince Aladdin, Little Mermaid, and Snow Queen.
Which, the thing with those is that's all, public domain.
Yeah, those are all Hans Christian Andersen stories that are public domain. You don't have to work so hard. The one, though, that I thought they did not really pull off was Ollie the Snowman. That character is not in Snow Queen, and if it is, it's not shown. It's not, visually depicted. Yeah. But that costume looked an awful lot like Olaf.
Yeah, it's not your traditional snowman, I think, and you get into it. I mean, there's a lot to be said for the fact that a snowman is a pretty generic, appearance character.
There's a lot of sans affaire there. He's going to have a carrot for a nose. He's going to have probably 3 body segments.
You got a lot of Frosty, quite frankly. Frosty the Snowman looks, although, a lot of times I think when you get into sort of what's a scene affair of a snowman, they don't have feet. They have usually. A bottom snowball that rolls around.
Interesting argument whether the amount of creativity required to give the impression of somebody else's idea without actually copying it. is pretty high.
Yeah.
At least the talent, at least. I can't do that.
Yeah, it's an interesting thing to sort of get into it. I think particularly if you get into something like, let's just talk Prince Aladdin, you know, which obviously, Aladdin is an ancient work, from
Oddly,
Arabian Nights.
I thought that Prince Aladdin looked the least like the Disney character of any of the ones that we looked at.
Yeah, but it's also one of those things where, there's a lot of scenes of fare in just what does a genie look like, so to speak. I mean, they almost always have sort of the billowy gossamer type, clothing.
Yeah,
sort of stuff
the
like
goatee, sort of the elfish ears is kind of a common feature. The wristbands, they keep them in prison. Yeah,
the imprisoning sort of things. And again, some of this is, it's stuff from the original story, so you're obviously, that's going to be public domain.
I assume it is. I've never
stage.
actually read Arabian Nights. I don't know.
Yeah, I've never read Arabian Nights either. But, you can encounter Arabian Nights all over the place. I mean, it used to be more than you can now. I mean, there was, the Aladdin Hotel in Las Vegas, which I stayed in, actually. I loved the Aladdin Hotel. It was a great place to stay. There's the Arabian Nights, like medieval times, dinner shows.
That's right, yeah.
There's all sorts of things that are based upon
done,
Aladdin.
like long before Disney did it.
Yeah, and stuff like that. And so the idea that, there's a Prince Aladdin out there and they have these general looks. Again, we talked about the idea of like docudramas and historical looks. These are things that are docudramas and historical looks. I mean, Aladdin has such
Even Little Mermaid. There was a 1980s adaptation of that.
Yes.
With Tom Hanks and I forget who else was in that.
Remember, it's pretty terrible if I remember really.
My sister loved it and watched it all the time. And from that alone, I learned to hate it. I'm also convinced, all I remember is that the mermaid didn't have a name and she used the name Madison because they happened to be standing on Madison Avenue when Tom Hanks asked her what her name was.
Okay.
And then, years later, a generation of women had girls and named them Madison. I'm convinced that's why. They all saw Splash.
That makes sense, as to, what it would be. Actually, no, Splash is a good movie, now that I think about it. I was thinking, isn't there another actual Little Mermaid?
There was a more recent one that was made. It was a live action, but I don't know if it came out or what happened to it. But it was not related.
I think there was like a straight to video one, or
that could be. There was a bunch of sequels too, but
yeah.
Okay, so Carlton or the Fortnite Carlton Dance case. I think possibly the same day or the day after we recorded and talked about this at length. There was a development. So
yes, there was.
Don't be surprised if the minute you listen to this, it's already out of date. So after our last episode, evidence surfaced in the litigation that the Copyright Office had denied registration on the Carlton on grounds that it was too simple. It's just hip sways and hand gestures, and that's not enough to qualify it as a choreographic work eligible for copyright protection under the Copyright Act. And I think it was provided in connection with motions to dismiss.
Yep.
So two things. One, it was denied registration. And then two, I assume it's Take Two or Epic or whoever the defendant is trying to get the case dismissed on those grounds. But we talked about this. The mere fact that the Copyright Office has said no does not necessarily end the issue.
Yeah, now you can obviously fight the Copyright Office on this issue. I mean, I've filed my own copyright registrations on behalf of clients, and I have done this. Mm-hmm. You can go back to the Copyright Office and say, no, I think your interpretation is wrong. Here's why it's entitled to copyright protection, stuff along those lines. So you obviously have issues like that. The other thing we've definitely got with it is, as well, we talked about that maybe the copyright in the dance, but there's also the issue of the copyright in the video
copyright
itself.
In the video, yeah.
Which is not necessarily subject to this, let's see where it goes. I think
but does Carlton own the copyright to the video?
Yeah, and that's where we're going to bump into the issues of where does this stand, where does this lie?
So
went
he's the
over
wrong
this repeatedly.
plaintiff.
Yeah. Last episode. But yeah, those are the kind of things I think you've got, it doesn't mean that this is over yet. There's some still potentially pending issues out there. I mean, this could still drag on for a year, even if this is found non-registrable. The interesting thing I think about it is that this was the Carlton, so obviously now the Floss, which is a much simpler dance.
Yeah. I don't like their chances.
Yeah, you've got to wonder if that's, if the Carlton's not registrable, that's almost certainly not registrable.
Yeah.
So then we're going to bump into, but then it sort of bumps into, well, what is registrable when it comes to a dance? Do we have an indication of where it needs to go beyond the Carlton? And I think that'll be an interesting question going forward, again, assuming that this denial of registration is upheld by the Copyright Office and is ultimately upheld by the courts, because you can challenge the Copyright
They may have responded already. We don't actually have, this is a whole separate issue, but it's weird. Patents and copyrights, if we wanted to, Kirk, we can just go right now and look up the prosecution status of most cases and see where they stand.
18 months after they're filed in conjunction with patents.
And trademarks are just
a week
out there.
or so after the filing of trademarks.
But the copyright prosecutions are not, but it's not that they're not public records. If we were in D.C., we could go down to the Copyright Office and pull up the files and do whatever we wanted, right? You could take a look. They wouldn't tell you no. because it's all public information.
Yes, it's public information.
They just don't have anything technical online to do it through their website, but the trademark and patent offices do.
Yep, and there's been a lot of talk of modernizing the Copyright Office and needing to go to things like that. But yeah, again, a lot of it is these are public records, but how public they are, they're public as of 1950.
Yeah.
And so it's interesting to sort of say when we say what's public then and what's public now is very different. I mean, there's huge amounts of public records out there that people don't realize exist as public records. Mm-hmm. You want a hearing from the FCC, a lot of those are public records, but I wouldn't expect you to be able to find any of them online. Now, some of them you can, obviously, but, not necessarily all of them.
Yeah, the federal agencies vary wildly as far as how much stuff they put online, and that's where a lot of the the administrative work all gets done. Congress doesn't do any of this stuff. They just pass laws and they delegate all of the rulemaking and enforcement authority and the adjudicatory authority to these offices, the Copyright Office and the Patent and Trademark Office and the FTC, et cetera. And then they issue rules and then they indict people. They call people in and institute proceedings and call people in to answer for what they've done and apply the rules.
Yeah.
And it's if you don't know how to find that stuff and how to navigate those procedures, then it's easy to get lost and it's hard to even know where to look for a lot of that stuff.
Yeah, it's one of the things that I think is really interesting is that these systems have, and I think this is something you encounter a lot in a lot of legal regulatory schemes particularly, these systems have oftentimes very good documentation, very good, search engines, even though recognizing the search engines may be card catalogs and older style things that exist out there for these. But if you don't know who to ask, where to look, and how the system works, they're impenetrable. Mm-hmm. But as soon as you understand how the system works, you can access virtually anything you want to. And I think it is sort of an interesting thing when you talk about the idea of the relay of information. We've all gotten very used to Google and the ability to just type a question into a search engine or say what you're looking for and it returns a result to you. But a lot of these systems, you have to know a little more of what you're looking for. Mm-hmm. Law generally is that way, but I think particularly when you talk about regulatory mechanisms, these regulatory agencies, if you work in front of these regulatory agencies, you can find anything you want. I mean, I can immediately find patent records. I mean, I work with them every day. But somebody handed the Patent and Trademark Office's webpage may not be able to find stuff immediately because they don't know what they're looking for or how to search for it.
Even people given a patent. I mean, if you have an issued patent, it's going to have the publication number, the application number, and the patent number. And if you don't know what all those things mean, it's hard to understand which, it's got an issue date, a filing date, a priority date, a publication date, and all those dates have different meanings under the Patent Act, and people who don't practice in patents can't tell which ones are important for which purposes.
Yep.
And if you try to go it on your own, you're highly likely to screw that up.
Yeah, I think that's the thing with it. And again, it's, there's some interesting stuff in conjunction with the regulatory stuff that's out there and what you can find in conjunction with regulatory. I think it's also where, it doesn't seem like anybody's talking about this. As we commented about, the copyright was denied. There was huge amounts of press coverage talking about the case.
Everybody covered the case when it got filed. And then I saw, this was on CNN, but it was a couple paragraphs. It was a short article that just said, and the denial itself, I mean, I don't know when it happened because I don't have a copy of the paperwork, but presumably the defendants got that in discovery. They must have asked for a copy of that stuff because it's not otherwise available to the public, so they couldn't get it themselves. So who knows how long, the plaintiffs could have known this was denied before they even filed the case.
It could have been denied previously. I mean, this could be something based on a prior attempt at registration, not even the current attempt at registration. We don't know. So
yeah, because the Copyright Office is running anywhere from a couple months to many, many months behind on these things. So if they issued a denial already, then the case must have been filed, I would guess, at least 6 months ago.
Yeah, probably.
Yeah. Well, let's talk more about patents. That's going to be the focus of today's video game discussion. How patents interact with video games. And I think on the whole, the answer is not very much, usually, unless hardware is involved.
Yes, I think that the thing you get into, I think, in conjunction with patents in video games, for the most part, is patents in video games tend to be hardware. That's not to say there aren't patents on video games related to gameplay. We touched on
They're comparatively rare, though.
They're comparatively rare, and usually when you're talking about it, it's somebody trying to get at sort of specific elements of specific kinds of gameplay. I know there was just an announcement talking about real-time strategy games, which unfortunately I didn't get a chance to look at that to see what was the issue in conjunction with real-time strategy games. But most of the time when you're talking about patents in video games, you're talking about some aspect of hardware to operate the video games. Which, when you hit the point of it, when you talk about a video game console or a video game controller or any piece of hardware associated with video games, we are talking about an electronic machine that's no different from a toaster. So when most people say, is a toaster patentable? Of course it is if it makes toast differently. So a video game console, to the extent that it plays video games differently, is also clearly patentable.
So let's talk about one specific patent, and we're not going to say what this is just yet. I'm going to read the abstract of the patent. And those of you who've listened know that we generally try not to read things to you, but I don't know any way to introduce this without reading this abstract. So
this is also, keep in mind, we talked about patent stuff with this. This is the abstract, not the claim.
Yeah, this is not what the patent actually covers. It's just the short description of what the general subject matter is. And this is probably going to take me about 20 seconds to get through. So here you go. You tell me what this is. A 4-directional switch, which can be turned on and off in 4 directions, seems redundant, which comprises a base plate having a plurality of electrodes formed thereon, a key top having an indication showing predetermined for pressing directions in an identifiable manner, a support member constituting a fulcrum between the base plate and the key top, a plurality of conductive rubbers disposed opposing to the plurality of electrodes, so as to be in electrical contact with corresponding ones of the electrodes, and a sustaining member having the plurality of conductive rubbers fixed thereto, and having elastic force for sustaining the conductive rubbers so as not to be in contact with the electrodes when the key top is not pressed. Kirk, what is it?
I know what it is because I'm looking at the patent thing here, but
it's the NES.
It's the NES keypad, yeah. And
patent number 4687200.
The one thing I'd say with it is I think the one thing that potentially gives it away is the 4 directions, and specifically being 4 directions.
But notice what they're talking about. We're not talking about a gamepad. It's a 4-way switch.
It's a 4-way switch. Yes.
It doesn't matter if it's in a gamepad or not. If you build a switch the same way that they've patented, then it's covered.
Now, I think one of the elements of related particularly to conjunction with this in video games is they specifically say that the key top has indication showing predetermined for pressing directions, which implies some arrows with it, which for a standard 4-way switch, I'm not sure you'd necessarily need. A light switch doesn't have arrows pointing up and down.
Yeah, it wouldn't have it unless it's manually operable in some way.
Yeah, but it's the thing that I actually love to do, and it's anybody who's ever taken a patent class from me. I've taught patent agency classes before, patent drafting classes to sort of everybody that's potentially interested, and also I do presentations just for business people doing patents. One of the things I love to do as part of one of my patent presentations is I pop various claims up and ask people to say, what does this thing cover? And one I love to put up is an electromechanical device, having an arm and a connected fulcrum and things like that for transmitting information. And I ask people what this thing is. And the answer to it is, it's a Morse code clicker.
I'll say it sounds like a telegraph.
Yeah, it's a Morse code clicker is what it is. And it's actually is from Samuel Morse's patent. In conjunction with it. But I always ask people, what is this thing directed to? And, I on a somewhat regular basis will get people who figure out it's a telegraph, it's something connected to it. But the number of other answers I get, which are all very reasonable, things like it's a cell phone, things like it's a radio. I mean, these are perfectly reasonable answers when you read this, but they're clearly not what's being talked about here once you sort of understand the context that it's in. This is a good example. As you said, this is a switch. We don't recognize that if you were to read this without saying anything about video games, you wouldn't necessarily recognize this has anything to do with video games. You just look at it and say, wait, this is a switch. It's some kind of, wall switch for a light, something like that. So again, I think it's a very useful exercise to sort of realize when people talk about this is what a patent covers and sort of what it is, reading it, you don't necessarily immediately get that.
Yeah, and I think people misunderstand, because this was something that was raised to me by somebody in our local game dev community and said, can you talk about the patent on that D-pad? And so that's why we're bringing this up, and it's interesting because I kind of assumed they maybe had a design patent on that. I would have thought a 4-way switch existed. I mean, it does exist, but not in the particular way that they've claimed. And this case, so this
a lot of this, I think, what probably got this for them is probably those conductive rubbers.
Yeah,
is probably what got it, because that's an intriguing concept of the idea of it being resilient bounce back and that it being conductive rubber, which is not a common thing. Yeah.
So this case was filed on August 5th of 1983, and it took 4 years to get through the patent office. The patent issued in August of 1987, and I did look at the claims, and they do track this pretty well. It's about a combination of the specific shape and contour of the pad. The claims also include the aspect that it has a dip in the middle, so it's more ergonomically comfortable. And it's really more about how the elements can be manually manipulated to temporarily open and close these various electrical connections, which are just the signals that are sent to the NES machine to know which button you're pushing.
Well, and the real key to it is keep in mind, you could push more than one of these, you could push one of them. You have to really get these signals right to be able to provide infinite direction.
And so, this case issued in 1987. So, Kirk, how long did it last?
It's gone.
It's gone now.
So it would have depended, because back in 1987, we would have been pre the change in law.
Yep.
So this would have been 17 years from issue or 20 years from date of filing.
Plus patent extension.
Plus patent extension, whichever was longer. So we would have to assume in this case it probably would have been 17 years from date of issue.
I checked. It expired in 2005.
Yep. So 1987 plus 17 years plus term extension, which would take us probably into 2005.
Yep. So during that time period, query, can Sega and PlayStation and Xbox, can they make game controllers that have 4-way switches that work the same way as this one?
That depends exactly what the claims are. Presumably, no, because it's structurally, they have to have, if they have these conductive rubbers, they have this structure as to what it is. The answer is no.
So they had to design their joysticks to work differently or pay Nintendo a license fee to do this.
And again, keep in mind, prior to this, prior to the NES D-pad, when we have the Atari joystick.
Yeah.
Which is also
had
a
a multi-way
switch.
Yeah.
We have the Intellivision track wheel on the bottom of that, or whatever that was called at the time. It's not called a track wheel. That's the iPad term. But the disc that was on the bottom of that was a disc of something disc, which in some sense is also a joystick. Instead of pushing the joystick sideways and having that push the edge down, you physically pushed the edge with your thumb, which allowed you to slide with it, which was the real key of the disc. I had an Intellivision system. I loved it. Played the heck out of it for a lot of years, and I used to love that controller, because it was so powerful. I remember when I first went to I never owned an NES, but some of my friends did. The first time I used an NES controller, I'm like, why can't I slide my finger? I literally didn't like the NES controller because I couldn't move it.
Did you ever use the two-way paddles on the Atari 2600? It was just a handheld paddle and just had a dial that turned left and right. And that's all
sort
it
of
did.
Vaguely, yeah.
And so you got the paddles, came with the Atari, but you also got the regular joystick with the one button.
Yeah.
The joystick already goes left and right. So why would you ever want to use the paddles?
Yeah, I think wasn't it because of games like Pong, where you specifically are doing linear motion?
I guess, or like the circus game had used those too. It never made any sense.
Yeah, or like Space Invaders, where you're specifically doing linear motion, because the problem with the joystick is you could move it up and down, which had no control if you're just doing purely linear motion, would be my guess.
Well, so I'll try and tweet out like a reference to this patent so you guys can take a look at it. So watch our Twitter feed for that. But if you look at the patent, the controller that they show in the drawings looks nothing like an NES controller. It's very different. And this is an important point that Kirk and I talk about a lot. People often talk about whether a product is quote-unquote patented. Do you have a patent on that? And I think it's a bit of a misnomer, because you don't actually, strictly speaking, patent a product.
Yeah.
You patent the idea behind it, right?
You patent inventions, and that's what you always got to remember. Patents are to inventions, to claims, for lack of a better term, is what it is, which could be a structure, a method, or anything along those lines. It's not specifically to a product. I think the reason why people a lot of times refer to it as a product patented is because of the marking requirements.
Yes.
Which is that the Patent Office does require you to mark products covered by the claims as patented or as covered by the particular patent number. That's a notice scheme. So somebody who looks at your product, looks at that and says, oh, there's a patent on this. I effectively need to review the patent before I can copy this. And that way, if I copy it, if there's no notice and I copy it, it's hard to say I did something immediately purposefully wrong.
How was I supposed to know it was patented if you didn't tell me?
Now, you still violate it, but the issue with it is that for purposes of getting damages, for purposes of saying it's willful, the person is assumed not to have notice because there was no notice on it. Whereas if you put on the product, so if you actually put on the back of the controller, hey, this is covered by the following patents, you now have notice that it is, you should go look at those, review them, and determine whether or not the aspects you're copying are covered by those patents.
So it's a difference between, I go buy a product right now at Target or Walmart or whatever, and I look at the box and there's no patent markings, and so I go make a company and we start making the same thing. And then 2 years from now, a guy says, "Hey, I've got a patent on that. You owe me royalties for all these products you've sold." And I'd say, "No, I had no idea. I had no reason to know. You didn't mark your product, so I'm not on notice."
And
I still have to stop at that point, but yeah,
you can still get going forward infringement because it's him walking in and saying, "You infringed my patent. Here it is." Now you do have notice. So going forward, you have those issues. Notice is actually one of those, I think, sort of legal concepts. We periodically throw legal concepts into this podcast that are just sort of general. Notice is a good one. Notice is sort of that idea in legal stuff that basically says you have to have some idea that what you're doing is a problem. And if you really have no idea that what you're doing is a problem, it's very hard to say, that you're liable for doing it until somebody tells you it's a problem.
It's a fundamental aspect of due process. You're entitled to two basic things: notice of what you're accused of doing wrong and the opportunity to defend yourself.
Yeah. So that's the idea, is that when you get into these ideas of patent notice, what the purposes of these sort of notifications, and you'll see it on products all the time, you see patent numbers for these products all the time,
usually designed
is to provide notice that somebody will look at my product and saying, hey, this thing's cool, but I could redesign it better. Oh, look, there's a patent. To go and say, well, let me load that patent, which is a public document, which is available very publicly from the United States Patent and Trademark Office, particularly if you have the number. That's about the easiest way to search. I mean, Google now has a patent search engine they've had for a number of years. It's relatively easy to get a patent number to load the search in to find out what it is. You can go look at it. You can determine what it is. Now, whether or not that means you can really understand what does the patent cover, what is the claim scope, things like that is a whole nother question. But for purposes of notice, it really says, yes, you provided with notice. We've warned you that there is a patent out there. Now it's on your head as to whether or not you've looked at it and made that determination, and whether or not that determination was made in good faith. Whereas if somebody just says, hey, I've got a product and I'm not going to tell you that it's patented, they can't sort of spring it on you later and say, guess what, it was patented. I got you for what you did a year ago. And it's, well, how would I have ever known that kind of thing, had occurred?
That's the same thing for the copyright notices. Maybe that's where some of the plagiarism misconception comes from, is, if I put a copyright notice and attribute the person who owns it, then I'm fine. That's not what the notice is for. It's not, I mean, there's an attribution, you can do, and that's nice, but that's not why we put copyright 2019 on things that are copyrighted. It's to tell other people this is copyrighted, so don't take it. One interesting point with that too is that the patent does not have to be coextensive with what we call the commercial embodiment, the actual thing we're sold or selling, and they usually aren't. In this case, it's just how this one four-way switch works. And
there's nothing about buttons. There's no A/B buttons here.
Nothing even about games necessarily.
Switch.
Yeah, and the power of the patent really is its breadth, B-R-E-A-D-T-H. The patent can cover a lot of things because you are protecting the invention in the abstract, regardless of how it's implemented, provided that it practices all the elements of the claims.
Yeah, as we say, it's a mousetrap is not patented, as a particular, wooden board and a metal spring. It's patented as the idea of like a swinging lever arm that's controlled by a biasing mechanism, sort of things like that. It's the concept of saying the way I catch the mouse is when the mouse hits a trigger, something smacks it. That's kind of the basics of what you're usually getting into. In conjunction with what is the power of the patent. I think the other thing to keep in mind, though, and I think it's one of those things you mentioned earlier with this, a lot of people get really tied up in the fact that they look at the patent and say, but the drawings don't show the end product. And the answer to it is it doesn't have to, and oftentimes it doesn't, because oftentimes the drawings are generated from precursor devices or are generated from somebody who came up with, hey, I've got this idea of a switch. We don't really know how we're going to implement it yet, but I have this thing that we have a four-dimensional switch. Would this thing have, 4 arrow keys on top of it? Would it have a disc on top of it and just have this being the underlying structure, which when you push on the disc depends on which pieces of it go down? There's lots of different ways you can potentially implement this. And quite frankly, I think that tangles people a lot in patents.
For sure.
Where they look at a patent and they look at figure 1 and go, but that's not what I'm making. And the answer to it is that's not the scope of the patent. Or they read the abstract and say, but that's not what I'm making. And again, that's not the scope of the patent. The scope of the patent is the claims and what is claimed in conjunction with it. And so when you start looking at what is the patent cover, what is a patented product, do I infringe a patent by making another product, you're never going to say what I am doing is exactly what's in the patent.
Yeah.
It's always going to be some issue of, hey, do you have all the claimed elements or not? You probably have additional elements over what the claimed elements are. You may have elements that, are arguably changed. But the question is, are they changed enough? And again, when you then compare it to a picture, where the picture may have nothing to do with necessarily what the end product looks like, which is covered by the patent, or certainly to be covered by the patent.
Well, people also misunderstand the thing that you ultimately sell doesn't have to practice the patent for the patent to be valid.
Yes, that's true.
I get that question every once in a while, like, well, will this patent cover my next generation of the product? The better question is, will this patent protect somebody else from making my next generation of the product? Because that's really what you want it to do. You don't need the patent office's permission to improve on your own product and move forward. And you don't even need your old patent to cover it. But if it doesn't, somebody else can potentially copy the new one if they can avoid practicing the patent as already written.
And that's sort of the coverage of it. When does it cover by it? The other thing I think you always bump into with people like having trouble of, again, what is it? Is it's connecting the patent to the product. And I think a lot of people look at it and say, what we sort of said earlier, is the product patented? And the answer to it is that's not really accurate. It's effectively, is the product covered by the claims of a patent?
So for the Nintendo gamepad, you'd put on there U.S. patent number and then this patent number, and then whoever wanted to make a gamepad would know to go look up what the patent is, and anybody who knows what they're doing would immediately recognize what part of it covers. It doesn't cover the A/B button and things like that, or the particular layout. There's nothing patentable in there.
Yeah, or the electronic communication scheme of how the signals are communicated, whatever the encoding might be. Those are the kind of things that you bump into as to what exactly does the patent cover. But again, I think when you hear it a lot of times in the popular press, you'll hear people say, "Oh, they patented the game controller." No, they patented a Switch.
Yeah.
And that Switch is a fundamental part of the game control. I mean, you look at the idea of the D-pad and say, would the D-pad have been the D-pad without this Switch? No, it wouldn't have been.
Yeah. It would have worked differently. But there are other ways to implement a multi-way Switch.
Yeah. Joystick.
Yeah. I mean, we already had them. We had arcade games before we had the Nintendo D-pad. Yeah. We had the Atari controller. These things existed. They were just developed differently. Like the underlying technology that makes it work is just different. And then other companies designed around it. And it's sort of it's widely misunderstood because you hear these patents get issued and there's all this outrage in the tech press about the absurdity of these broad patents that cover things that we've all known about forever. Nintendo got a patent on the gamepad. Why, we've already had those. No, you didn't. You didn't have this gamepad. You had other gamepads, and likewise, you can make new gamepads that might even be better that don't infringe this patent, which is exactly what happened.
Yep, and I think that's again a lot of what you sort of bump into is you bump into a lot of the sort of tech outrage about it is people not necessarily understanding exactly what the scope is. They effectively too quickly connect this patent to this product, either because the numbers on it or because of whatever it might be that they're seeing where they want to see is sort of something that's overly broad.
There's a little confirmation bias, right? If you hate the patent system and you hear about a patent that sounds absurd, it just confirms to you, right, that you were right.
And again, I sort of talk about like presentations I do. One of the ones I always talk about is I always talk about the thing and say, we all are aware, and I mean, you can go and you can see the original patent, specimen that was provided, that Thomas Edison patented the light bulb. And the answer is no, he did. There were actually light bulbs patented before he ever filed for his own patent. And there's been thousands of patents filed since he got his patent on light bulbs. Mm-hmm. And the example I always use with it is I say, since Thomas Edison got a patent on the light bulb, he got a patent on this. And I show a drawing of a compact fluorescent. And it's, no, of course he didn't.
Not, yeah.
It's a totally different technology. But we look at it and say he invented the light bulb. And the answer is no, not really. Really, he invented a particular form of light bulb. In many respects, the most important thing Thomas Edison invented about the light bulb was the socket it went into.
Yeah.
More so even than the light bulb. And there's a reason why they're called Edison sockets. But, it's those types of things where I think a lot of people, when they look at the patent system and they say, hey, this patent covers this is what somebody invented. Again, they readily jump from patent to product. And it's not something you really want to do.
It's not a clean leap every time.
Yeah, it's not a clean leap. It's actually very rarely a clean leap.
Let's talk about one more thing Nintendo tried to do to protect their controller. We said the patent expired in 2005, but that was not actually the end of this. There is one form of IP that lasts potentially forever, Kirk. What is that?
That would be trademark.
The trademarks. And we've talked about how, we've speculated, I should say, that we think one reason Disney has started to use a clip of Steamboat Willie as their logo at the beginning of films.
Their Disney animation logo.
Yeah, it's to get what's called acquired distinctiveness in the clip so that Steamboat Willie will essentially be trademarked forever. Okay.
Well, at least that
particular
2 or 3 second clip as to whatever it is.
They'll argue that to use any part of it would be confusing, but we'll fight that battle in about 6 years.
If anybody feels like dealing with it.
Yeah. I think people are just going to stay clear. But anyway, Nintendo tried something different. In 2015, they filed a trademark registration on the NES controller. The case is 86/565763.
Now let's keep in mind, this is a trademark application number. That's not a trademark number, and those are different. You don't get a registration number until it grants. This is an application number.
Yeah. So this is them claiming they have a trademark interest in it. It's not. And that's kind of what the prosecution process is going to figure out. The trademark office rejected this. They said that it was essentially a non-distinctive configuration of packaging, and that to the extent that there was a design, it was ornamentation and not a trademark. And this is sort of why we sometimes get these questions when people come up with like a hilarious slogan for a T-shirt and they want to trademark it. You're not supposed to be able to do that.
Well, remember, your trademark has to be associated with the goods and services underneath it. So basically, the idea of this is that the trademark, the D-pad shape needs to essentially be an indicator of origin of the Nintendo company, essentially for the NES, for video game systems. And you can kind of see where the trademark office is probably coming at a little bit. No, it's just the appearance of it. It's the ornamentation of it. It's not actually the indication of it. Everybody knows, however, an NES, we know exactly what you mean. A Nintendo Entertainment System means this box produced by Nintendo.
So Nintendo submitted remarks in response. I'm going to read these as well. They're relatively brief. This is a statement made under oath by Nintendo's trademark lawyer. Through years of investment and promotion by the applicant, Nintendo of America, Inc., as well as through tremendous loyal customer support, the design of the Nintendo Entertainment System controller has become one of the most recognized intellectual properties in the video game industry. I'll stop there. Kirk, would you agree with that?
Yeah.
Yeah, I would agree.
I don't have any doubt whatsoever that I think the NES controller is one of the most recognized iconic controllers in the game industry.
When consumers encounter the design of the NES controller, they only think of one source, Nintendo. Agree.
Right there, that's the idea of trying to connect this thing is to the trademark has to be an identifier of source.
Yep.
You have to know that based upon this appearance of this controller, you are talking about Nintendo.
Either because it is inherently distinctive or because it has acquired distinctiveness, Nintendo respectfully submits to the examining attorney that its two-dimensional design of the face of the NES controller, including the verbal elements Nintendo Select Start A and B, is a distinctive design mark that warrants registration in connection with Nintendo's Class 28 goods, which is video games.
Video games. It's video games or video game systems?
Yeah.
No, it's video games. It's video games.
So let's talk about, they mentioned inherently distinctive versus acquired distinctiveness. So there's two different things here. And we don't have enough time to go through the spectrum of distinctiveness, but the first argument is that it is inherently capable of uniquely identifying Nintendo as the source of goods. And then he's saying, even if it's not, we've been using it exclusively for so long, everybody associates it with Nintendo.
Yep. So this is the common thing you bump into, and anybody who takes trademark law at any form of law school, or even if you go and review like trademark law books or even trademark law on the internet, you will encounter this idea of the spectrum of distinctiveness, which oftentimes is referred to as generic, descriptive, suggestive, arbitrary, fanciful. And basically what it says is that certain things there's no way they would be associated with anything.
They're inherently incapable of uniquely identifying a source because they're just the generic word for something.
Yeah, you can have, so the one that's I always commonly sort of joke out is apple for a fruit is the generic name of it.
Yeah, I can't trademark Apple.
Yeah, Apple is not the generic name for a computer. That would be computer.
Or a British record label.
Yeah. To talk about, sort of other interesting cases that are out there. But yeah, so you kind of bump into those things of saying, hey, we have these networks that are just simply totally disconnected with things. The reality of it is the vast majority of trademarks we encounter in many respects fall on the pretty distinctive side. Their names are things that aren't necessarily associated with anything in particular.
Yeah.
Why is the name Burlington associated with coats?
Or shipping.
Or anything else? Well, because we associate it with it, stuff like that. So those are the kind of things that you definitely bump into as to sort of the far end. The other end of it is what are called descriptive or generic marks, which are marks that are not necessarily something that is completely unrelated to what it is. It is somewhat descriptive of it, but it's entitled to maybe become descriptive. And that's the difference between generic and descriptive.
Descriptive is more like a mark that describes qualities or characteristics of the product. So the example I always use is sharp as applied to knives. Well, that's kind of a word used to describe a knife. It just describes what it is.
Yeah.
And we don't want people to have trademark rights over that usually, because then if anybody else says we have sharp knives, and they've infringed a trademark, and that just seems wrong.
But the one I love to pick on, and actually I use generally in conjunction with, is U.S. Bank. It's a bank in the United States. So it's a U.S. bank.
Banks are famous for having terrible names.
Yes. At the same time, everybody knows exactly which bank I referred to. As soon as I said U.S. bank, it's not like I'm referring to a general banking in the United States. I referred to a particular bank, and we all know it. That's the meaning of acquired distinctiveness. That's a mark where we look at it and we say, we know which bank it is. So yes, it has acquired distinctiveness, even though arguably the term U.S. bank is descriptive.
It's been used for so long that everybody knows now. Yeah.
Yeah, and that's banks are actually, I always think, is sort of one of the best examples of marks which are almost very far on the descriptive end of the scale, but also have acquired a lot of very strong distinctiveness.
I think it's such a pervasive practice to name banks that way that people just kind of figure, if there's a First Federal National Bank, then it's probably different from the First National Federal Bank.
Yeah, exactly. And that's those kind of things. Sort of, banks are notoriously named. I think there is some regulatory stuff. I don't know banking law, but I think there is some regulatory stuff about how you have to name banks. But there's a first bank, there's a second bank, there's a third bank, there's a fourth bank, there's a fifth bank, stuff like that. You bump into these kind of things where it's like people just can't seem to come up with, reasonable names. But at the same time, we all know which banks we're talking about because they do acquire distinctiveness. And I really like that example as sort of what acquired distinctiveness means, because I think it's very, very clear when you say those kind of things. Again, if I say Bank of America, we all know what I'm talking about. Although, that is a very clear, distinct bank.
Like Bank of America, we know is one bank, and U.S. Bank is a different bank.
Yes.
But how different is Bank of America from U.S. Bank as far as what it tells you about it's a bank in the United States.
It's a bank in the United States. And so when you look at the idea of the sort of, were those marks that are inherently distinctive? No, those marks are not inherently
distinctive. U.S. Savings and Loan,
Yeah, but they are clearly acquired distinctiveness, and I think that's sort of a great example. Again, inherently distinctive marks, a lot of times when people say them, it's a made-up word.
Yeah,
it's something
nonsense.
Which is
Xerox.
Yeah, Xerox, or something which is disconnected, like Apple with computers.
It's arbitrary. Yeah. Well, Nintendo did not win on inherently distinctive, but they did win on acquired distinctiveness, and the examiner said that if they amended their application to say that it was acquired distinctiveness, they could have it. And they did. So Nintendo now has a registered trademark on acquired distinctiveness for the design of the controller. So question, does this mean that nobody can sell a controller that looks the same?
Well, I think one of the things you bump into is what exactly is the mark covering, and I specifically note the phrase by the Nintendo attorney that it's two-dimensional design of the face of the NES controller, including the verbal elements Nintendo Select Start A and B. Definitely is implying that those are part of the design.
Yeah.
And so I think
what if you leave them off?
Yeah, so then you bump into the question, what if those are taken off? What if you move the positions of the buttons? This is where you get into the question of
or
what
change
is
the design
functional?
of the face.
Yeah.
I think the scope
Make it
of this
vertical
is
instead of
probably
horizontal.
narrow. Yeah.
I mean, that's the one that I always think, again, treat the Intellivision pad, which was vertical, as opposed to being horizontal with it. So can somebody make it sell a controller that is similar? Yes, there can be ones that look similar, but have, sort of different components. There could be ones that use the same components, but they're rearranged. Would those comprise trademark infringement? I think then it depends on the eye of the consumer.
If you just disclaimed it, you sold one and it said not sold by Nintendo of America, Inc. Now you're into tarnishment and dilution and things like that.
Yeah, and I think we also all have them. There's a number of controllers, not even the initial, NES controller, but the sort of more modern NES controllers. There's a lot of variations on those which are sold, many of which have additional buttons, where it bumps into, is that really something where you can say that's an infringement because it's got different buttons. The buttons are labeled differently, they're positioned differently, oftentimes to the detriment of the user because you can't figure out where start is, particularly if it's got extra buttons. But those kind of things where you have that, there's a functionality argument that all I'm doing is copying the functionality. Yep. And again, without the patent in place, which we know is not in place for our four-way switch here anymore.
Well, that's an important point, too, is that this trademark covers the way that it looks and the way that it's laid out, but it doesn't extend the patent in any way. You can make something that works the exact same way now.
Yes, I mean, to use the same way that this patent is expired to the four-way switch, I assume there's no continuations, anything else that they filed in conjunction with it, but to at least the claims of that patent expired, in 2015, you can build that exact four-way switch.
2005.
2005, sorry. You can literally walk through and build it exactly as it's described in the patent, and there's not a thing anybody can do to you.
About it.
And that's one of the benefits of the patent system. That's part of the goal of the patent system is to say that once this exclusive period has run out, people can build these things. They can improve upon them. And that's part of the goal of the patent system is to say we want that to be public knowledge. Part of it's because somebody could look at this now and say, hey, this is a great four-way switch. I have a new material that I've just come up with. I can make a really cool eight-way switch, which couldn't have been built in Nintendo's time. But now that I know how Nintendo built the four-way switch, I know this would work for an eight-way switch, and here's a better design. And that's part of the goal of the patent system.
Yeah, it's fundamentally, conceptually, I should say, it's supposed to be sort of a compact between the inventor and the public. You tell us, the public, how it works, and if we want, then we'll give you a temporary monopoly. And in the grand scheme of IP, they're pretty short-lived monopolies. They don't feel like it to us on a day-by-day basis, but they do end. They do end in our lifetime, which is more than we can say for most other IP rights.
Yeah, and it is interesting, sort of in the patent realm. We're talking about something, the NES system. Most of us, grew up with. I mean, we definitely grew up with. I mean, to me, it's not even an old system. Atari and Intellivision are the old systems.
Yeah, those are the old
Commodore
ones.
64,
Amiga.
Tandy.
Don't throw a Tandy, oh no.
Let's talk about Radio Shack.
is a vestige from the past.
But those kind of things where we look at and say, those are really old. The Nintendo was the modern version for a while. And yet its patents have run, this is technology
they ran a
that's gone.
decade ago.
Yeah, it's, this technology is stuff which is generally out there. And so I think a lot of times when people look at it, they're like, oh, it's so bad that this thing is patented because it's going to run for so long. And the answer to it is not really, actually.
Yeah. Did it stop Sega from making controllers? Did it stop us from having even bigger, better controllers that have more, even easier to use inputs? I mean, how many people prefer that Nintendo D-pad over like a modern controller?
Yeah,
I do because I'm old school, and these new controllers are too confusing for an old guy like me.
Yeah,
but
I didn't even use a controller. I use the screen. I do most of the stuff on iPad.
Yeah,
so
who needs a controller anymore? That's dinosauric. All right, well, we'll wrap this up and get moving along here. I think next time we're looking at bringing in a special guest to talk about a very off the beaten path topic, but we're still trying to firm that up. And then after that, we're probably going to launch into our long teased bit on music law. We've had multiple requests from people to get more into music law and how that works, and maybe a little bit more on the Modernization Act and some of the nuts and bolts of these copyright issues. So there's the music, and it is time to go.
Speaking of music.
Yes, if you have questions, comments, topic ideas, criticisms, complaints, remarks, adulations, or rants, you can send your thoughts to us on Twitter. That's right, Twitter at LGGpod, or emailed us at lggpodcast@gmail.com. Did you like my crack reference there?
Oh, yes. That definitely was just a Twitter joke in conjunction with it. And should we mention, by the way, Twitter is not necessarily modern technology.
No, that's also old. They had that when I was in law school. That's really old. You can talk to us on our Facebook page, search for Lawyer's Guide to the Galaxy, and find us there. Subscribe to this podcast on one or more of the platforms or all of the platforms. We are on iTunes, SoundCloud, Spotify, and all of the other places where you go for your podcast content. If you like what you hear, give us a review. Reviews are how we attract more listeners by making it easier for others to find us. You can get me on Twitter at Benjamin Siders, and Kirk is at KirkDMN. That's all for today. We'll see you next time. Lorem, play us out.
The views expressed by the participants of this program are their own and do not represent the views of, nor are they endorsed by Lewis Rice LLC, its officers, directors, employees, agents, representatives, shareholders, and subsidiaries. None of the content should be considered legal advice. As always, consult a lawyer. This podcast was produced and recorded at Cool Fire Studios in St. Louis, Missouri.